A little bit more with our legal experts, Robert Driscoll, former U.S. Deputy Assistant Attorney General, and Karen Tumlin, Legal Director for the National Immigration Law Center. Appreciate you both being here. Robert, start with you, sir. Do you agree with Mr. Dershowitz's advice there?
I think I do. I mean, I don't think there's any harm to a request for en banc and maybe getting a dissenting opinion or something that would lay out the administration's arguments. But I think they're going to two-track it. Break the executive order up into smaller executive orders that are clearly within the Constitution and just go forward while letting the Ninth Circuit litigation linger and maybe going back down to Washington and having a full trial there. So I think that the two tracks make sense, and from what I understand, that's what the administration is going to do.
Karen, we've seen this sort of cherry picking, if you will, of courts and jurisdictions to fight the executive order in, whether it be Boston or whether it be Seattle. Big picture here, is there any part of this executive order, whether you agree or disagree with it, that you believe the president is within his right to do?
You know, so obviously my organization, the National Immigration Law Center, is challenging the executive order in court because we think, as written, it is unconstitutional and discriminatory. I do think what we can all agree on is that what we want to do is uphold our value of, protecting the security of the United States while balancing that against constitutional rights.
But to that point, Karen, does the President of the United States, and for that matter, the executive branch, do they have the right to decide who can and who cannot come out of the United States if they're not U.S. citizens? Isn't that part of the executive branch's right?
So the executive branch, certainly through the Federal Immigration Agency, has authority over immigration policy, but they do hit up against the Constitution. And what we've seen with this executive order is the president has taken a bat, if you will, to immigration policy when what is required and what has been accepted traditionally is taking a fine-tooth comb.
It seems like we may have lost Karen's mic there for a second. Robert, do you agree with that analogy, the bat versus the fine-tooth comb? And it seems as like what you and, for that matter, Alan Dershowitz are arguing, what the president alluded to, is bringing back the comb.
Not necessarily bring back the comb. I think that it hasn't brought a bat to anything. The executive order, I think, though flawed in some respects, was constitutional. And I think there's plenty of policy arguments opponents of the president want to raise. But I think it's pretty clear that it's within his right to decide who does come in and out of the country. I mean, particularly with respect to non-citizens without visas who are overseas, they don't have any constitutional rights. And so to invoke the Constitution in that context is crazy. And immigration law itself, immigration policy, is per se discrimination based on national origin. I mean, when we let people from Europe fly in without a visa and treat the rest of the world differently, we're discriminating based on people's place of origin. And that's what immigration law is. And so I think that the Ninth Circuit overreached. But I think, be that as it may, as a practical matter, the order was 90 or 120 days anyway. They won't get relief in that time frame. And so it makes sense to go back and start again with a couple of separate orders to at least take care of the obvious parts that are constitutional and clear, and make that clear and let those parts be litigated.
So Karen, I want to bring Karen in because she's one of the groups challenging this. If the president comes back and reissues an executive order that, for example, has everything the same as the first executive order, but makes it clear that green card holders are allowed back in, are you okay with that?
No, and let me tell you why. So first of all, and you see this in the Ninth Circuit's recent ruling. First is, we're not only talking about the rights of individuals with other kinds of visas abroad. We're talking about their U.S. citizen family members. What about their rights to be reunited per federal immigration law with their loved ones who are abroad? So I want to make sure that we're looking here. First of all, the Constitution protects us all, but secondly, the only groups affected are not some hypothetical set of individuals on foreign soil attempting to come in.
All right, Robert, does that jive with sort of your understanding of the law here?
I think that's very unclear that there's a constitutional right of people outside the country who don't have another kind of right to get in by a green card or a visa. And I think this gets back to the point of, standing in this case is very dubious to begin with, that the state of Washington or the state of Hawaii or California I don't think they can assert the rights of those people. I mean, if they could, simply because they have state universities that have foreign students, every military action taken by the president will call up reservists and affect students at state universities, and so we don't want.
Can they then come back and sue the president? Interesting to note, though, that when you listen to the Ninth Circuit argument, so much of it and the judge's questions was about sort of the validity of the ban or whether it was a good idea or a bad idea rather than the constitutionality of it. More on that later. Robert, appreciate you being here as well. Karen, come back and talk to us as this continues. We appreciate it.